And good evening, and welcome to Chas Calenda, Attorney at Law, an inaugural episode, if you will, of a show that we're developing in order to, using the Coalition Radio Network's airwaves, to bring, legal conversation on a variety of issues, if you will, engaged in and around the criminal justice system of the state of Rhode Island. Now, like most shows, we'll start at a certain point here. Tonight's going to be kind of a casual conversation, and it will evolve, and we'll find sort of the right ground, if you will, to cover on a weekly basis and bring some accessibility to some relatively complicated legal scenarios that Rhode Islanders face on seemingly a daily basis. One of the things in the coalition, when we often talk about, is something called the pipeline to prison. And the pipeline to prison is very often a civil infraction or a minor criminal infraction that, when not dealt with properly, will just snowball. I'm just going to tell you that the stuff never goes away. The brain, a.k.a. the criminal justice system in Rhode Island, will never let you go once they get you in their grasp. So rather than deal in the urban legends, the myths, the confusion, the chaos, and as I always say, what they'd have you believe as what they're supposed to believe, we're going to try and tackle that on a weekly basis. I want to welcome someone that I've gotten to know over the last few months, and I consider a pal and a friend, Chas Calenda. He is, and I'm going to let him go through some of his CV, his curriculum vitae, as they say. But ultimately, he is an attorney with an intense focus on criminal law, having spent time in the Attorney General's office of the great state of Rhode Island, trying cases, and now he's in private practice and has a real-world perspective that's difficult really to compare to. So the first thing I'll say is that this is, you won't hear any booming sound effects. This is certainly not a certain crime show on TV where, the first 15 or 20 minutes is dedicated to the commission of said crime, and the rest of the show is the prosecution of said crime. All of us have gone to, I think we could say we have a degree in special victims unit, just like we have a degree in epidemiology, and just like we have a degree now in mask wearing. The entire purpose of this show is to eliminate that kind of madness. Chas, first of all, thanks for joining the Coalition Network. I believe something like this has unlimited potential. Welcome aboard, and just talk about your background and how you've arrived at the point you're at today with a successful criminal law practice.
Well, thanks for having me back, Pat. I appreciate your allowing me back on the coalition. But, you just kind of gave my standard opening statement when I do a criminal jury trial that, don't expect everything to be wrapped up in 58 minutes or as you see it on Law & Order SVU. Seeing it on both sides of the aisle has become an eye-opening experience for me. As you mentioned, I started my career doing 12 years as a criminal prosecutor for the state of Rhode Island with the Attorney General's office, and I can't think of an issue that I didn't see going through that period. I think I prosecuted almost every single type of crime that could exist in the state of Rhode Island. And since leaving the Attorney General's office and going into private practice with the law firm of Inman and Torgy over here in Coventry, seeing it from the other side in the perspective of criminal defense has also given me I think a pretty unique perspective on the problems that we have with the criminal justice system, not just the way that the laws are set up, but the way it's practiced, the way the people who are the players in the system administer the criminal justice system, and just how it plays out in the real world as opposed to how it was probably intended to play out.
I guess you're in law school, and how did you end up, if you will, becoming part of the criminal justice system? Was it a practice that was motivating you? Was it simply where you had an opportunity to do some internship or some student law? Give us sort of your backstory.
Well, my backstory and how I got involved in law is actually kind of funny. I went to school at the University of Miami. I was there for communications, but they make a double major, so I did criminology as a second major. And I had no interest at that point in going to law school. I'd always been interested in listening to the legal issues that we talked about in school, but it wasn't a passion of mine. But I didn't become interested in the law until I was watching the litigation play out in the 2000 election and listening to the arguments being made in the Supreme Court that they actually were live broadcasting, I believe, at the time, which was pretty rare for the U.S. Supreme Court. And I remember being fascinated by the legal issues that were involved there. And I said to myself, I like the communication aspect because it kind of overlaps with what I would like to do as a lawyer, which is be in court as opposed to sitting at my desk and writing contracts. But I became fascinated with that, and I geared my classes more towards a political science perspective and a legal perspective, so I could prepare myself to get to law school.
Let's talk about the reality, if you will, of the criminal justice system. What type of cases, and I understand working for the Attorney General's office, you probably can't get into real specifics, but talk about some of the array of cases that you actually tried.
Ooh, well, my first cases were in the juvenile system, to be honest with you. You go into the Attorney General's office in one or two places. You either start in juvenile prosecution, where you have delinquent matters with kids under 18, or you start in the misdemeanor unit, which is the district court unit. And I went to the juvenile unit, which is completely foreign language to anybody who's even studied law. You go to law school, you learn about contracts, property law, and all those kind of things. And you walk into a juvenile courtroom and they're using a completely different language. So I did 3 years doing that. So my first cases were all juvenile cases, which were offenses which would be felonies if were committed by an adult. So I probably did about 10 to 12 of those in my first 2.5 years in the office before moving to the adult system, where you start trying misdemeanor cases. But my first real case was a prosecution of a person who was carrying a firearm without a license. And that was my first jury trial in the state superior court. And I remember doing that in front of a judge that is widely considered to be one of the toughest judges in the state, Judge Krause. And I remember that being a very intimidating experience, but one that was also very exciting.
Did you win?
I did. There was actually a what we call a Matlock moment, and I know that kind of dates right. Not me necessarily, but it's dated reference for a lot of people. But the person had claimed that there were multiple people in the car, and he claimed that the gun wasn't his because it wasn't right on his person, but it was hidden somewhere in the car. But when we were cross-examining him, and I think I had a good question, he referred to it as my gun, and I kind of turned around and almost fell over the fact that he just admitted that it was his gun. Wow. So it was one of those moments that you can only dream about as a lawyer.
Was there a sound effect? Did the music in the courtroom swell up?
The only sound effect I remember was my podium almost falling over.
You see, there was a great moment in a movie called "I'm Gonna Get You, Sucker," which was by the Wayans brothers. And there's a point when the provocateur in the movie is walking down the street and he says, "You know what? A hero's got to have his own theme song." And as a result, he had musicians who followed him everywhere. In the I'll intone it the best way. In the legal world of Providence, Rhode Island, is there in fact theme songs? Let's talk about the reality of these cases. There's so much. I'll constantly refer to the term urban legends because it's probably the most polite way I can put it. Is there in criminal cases like that? I mean, how many of them come to trial? How often are they pled out? We supposedly have a gun court in this state, so let's talk about gun cases for a little bit. Give us the whole, if you will, story about how it really works in the real world.
You are right. There is a gun court in Rhode Island. It's only in Providence County. It's in the Superior Court in Providence County. So no other county in the state has the gun court, and it's overseen by two judges. One was, I just mentioned, and the other one was Judge Kristen Rogers, who is now helping with that calendar. But essentially, my advice to anybody watching this is do not commit a gun crime in Providence County, because you will be going to prison if you are convicted. But the reality of these situations is a lot of the cases are pled out because the state has a lot of leverage with the type of gun laws that we have here in Rhode Island. Yeah, specifically speaking of the gun laws, they are one of the few areas of criminal law that have mandatory minimum sentences, where the judge has no discretion to impose something different than the mandatory minimum. They can only go above it. They can't go below it. So, for example, if you're using a firearm during the commission of a crime of violence, whether or not you injure somebody or kill somebody, there is a mandatory minimum prison sentence, and you will go to prison unless the state drops that charge or you are found not guilty. So that gives the state a lot of leverage, and quite frankly, people who are up against that have to make a decision. Am I going to roll the dice? I may have a very valid defense to what that charge is, or am I going to take what might be a plea bargain that maybe I don't love, but keep me out of jail for 5 years. Maybe I only go for 6 months because they're willing to reduce the charge and save the state their time and money of putting the witnesses on the witness stand.
Well, and that brings up an important point, is what's the rationale, the real rationale, and I'm not suggesting this is good or bad, but just from the state's perspective, why do they plead cases out? What's the motive?
The case, the backload would be incredible if they didn't plead cases out. And many times that's I think that's the overwhelming the reason. But there's also a lot of cases where the state does not have a great case. And as you know, proof beyond a reasonable doubt is a pretty high standard. It's the highest standard known to law, under the law in any of the systems, whether it be criminal or civil. And when you have a prosecutor evaluating their case, there's a lot of showmanship going on, shall we say, between the prosecutor and a defense attorney. So the prosecutor is going to try to beef up their case as much as possible, but at the end of the day, come back and say, listen, maybe if we plead to this charge as opposed to this charge, we can work out something in the middle here, and we both get something of what we want. Because the reality is, at the prosecutor's office, most of them are not acting under their own discretion. They're being told what to do. They're being directed to handle cases in a certain way, and that's coming directly from the top. And it's not just this administration. That's been going on for decades in the state of Rhode Island, and not just the state of Rhode Island, in many states. It's an unfortunate reality of the system.
Another facet of television law is that there is a group of detectives. Usually they're on a team. There's always a team. I don't know if you ever noticed that, a special team. And usually they travel by plane or by fancy cars that they've been given to by the state. And I know you probably had a really fancy car when you were working for the state's attorney general. Did you have like a Barracuda or something that they taken from a drug dealer?
Something like a Gremlin, maybe.
But since we're puncturing myths or trying to sort of set the stage for how we go forward with the show, you've always got this case on TV of the one detective who is just going to follow it through. And there's two things remarkable about it. They spend their own time, they work nights, weekends, whatever, to clear the wrongly convicted. And at the end, they always have a tearful, heartfelt reunion outside of the case, outside of the court afterwards, in which they all celebrate and go to lunch, like Matlock, right? So, on a non, and we're, the purpose of tonight is to really paint with a very broad brush. This is not clinical. I mean, I'm hoping in the future we'll get into some areas where you'll have the opportunity on a case-by-case basis to get fairly clinical with people and really analyze the situation. But generally speaking, I mean, how much resources can say, for example, the Providence Police Department, and I'm not picking on them, but a big city police department really dedicate to a case that doesn't involve I'll call extreme violence and or huge property loss?
I'll use an example from court to answer your question, Pat. Providence is going to focus, obviously, their resources on the extreme violence cases, the murders, the cases that deserve their attention. But to answer your question in kind of like a funny anecdote, I was in the Wakefield District Court, which is down, the fourth Division District Court, and the judge down there was asking one of the defendants whether he could make the next court date, and the defendant had told the judge, "Oh, I'm sorry, Judge, I can't make that court date. I have a court date in Providence." And the judge asked this defendant, "Well, what do you have in Providence?" He goes, "Oh, I got pulled over for reckless driving in Providence, so I have a court date in Providence." The judge started laughing and saying, "What do you have to do to get pulled over for reckless driving in Providence?" And I guess, would you have to like run people over for on the sidewalk? Like, what do you have to do? I've never seen them actually charge anybody with that in Providence. It's usually some sort of like murder, gun case, sexual assault, something along those lines. But it was a lighthearted moment because the life in Wakefield is a little bit different than life in Providence, and he just couldn't believe that they're actually dedicating resources to something like reckless driving in Providence.
Right. So there really is no dedicated and I shouldn't say it this way. There really is no special crew of detectives who are out there taking on the case on their own after, and what's the rest of the narrative? After they've been pulled off the case by that angry sergeant or that angry detective sergeant. And if you notice, they're always angry, right? They're just angry at the world. And there's this special team of people, the two police detectives, who managed to, within 24 hours, or at least 90 minutes because it's TV, right, integrate themselves into a high level of an operating functional gang unit in order to get firsthand evidence to prove the if you will, the integrity of their client. That doesn't happen either, does it?
I mean, there are dedicated groups for certain types of crimes, like crimes against children. There are, there are groups like that. There is a homicide angle. There's a homicide group that there used to be a group called the Jump Out Boys, I think they called them. I think that group has since been disbanded. But there are groups that do handle certain types of crime, but it's not the the way you described it and the way SVU portrays it in some of these cases where they work in days and nights, and the last minute everything comes together in a nice, neat fashion, and it answers everybody's questions and solves all the world's problems.
Because they usually also have their own like special cool building, right? Their special hideaway for their special department. I like I said, I'm an expert because I watch lots of late night TV. I'm being a little flippant about a deadly serious subject. If you're incarcerated / arrested for a criminal offense, and let's just use Providence as an example. You're picked up. Maybe you got into a fight. Someone was hurt. Lead us through the steps, if you will, from arrest to arraignment to temporary incarceration. Where do they go? Just kind of lead us step by step through that process.
Well, for the typical arrest that's not a capital offense, you're going to be brought to the police station, or if you have a good lawyer, you'll have that lawyer arrange a time where you could turn yourself in at a mutually convenient time. So you can go to the police station and be processed. Any good lawyer will tell you give no statement to the police, even if you are a completely law-abiding citizen and support the police, as I do. I support the police and the jobs they do, but I still would never let my client make a statement to them when it involves their potential criminal liability. But you're going to be brought to the station. You're going to be afforded a phone call. You should already, at that point, if you have somebody who likes to plan in advance, have a relationship with a lawyer so they can be your first call, or the first call be someone to arrange bail if necessary. But they're going to print you, they're going to book you, they're going to take all your information. And if it's during the night, if you're lucky, you'll have a bail commissioner come out and set bail and give you a date of return to court. If you're unlucky, you're going to sit there in the jail cell, especially in Providence. You're going to sit there in the local jail cell until the next morning when they bring you to court and arraign you, and then a judge will determine your bail at that point. If you're already on probation, or you're already on bail for some other offense and you've been arrested again, you're likely going to sit there, and then you're going to be sitting in the ACI for the next 2 weeks until they determine what they're going to do with you.
So even, and I'm not trying to minimize any of this, let's just say people come to blows outside of one of our famous, if you will, or infamous Rhode Island adult entertainment institutions, which have been part of the landscape here for decades. And they come to fisticuffs. You're brought down. How does bail really work? I mean, I have never had to bail myself out yet. But how does it actually physically work? How do they determine if in fact you're? I would imagine, is it a constable at night, or if you're busted in Providence over at the Foxy, where are they taking you? And what's it going down? When are people around to arrive at bail?
Well, there's one of two things that's going to happen. Let's just say you just get picked up for the standard run-of-the-mill misdemeanor. You've never been arrested before. Mm-hmm. So one of two things are going to happen. They're either going to issue you a summons to appear for a future date in court, and so you won't even have to deal with bail that night. That's for the people they like. If they don't like you, or you have some sort of prior record, or maybe it's a little bit more serious of an offense, they're going to bring you to the station. They're going to do all the booking and processing, and then they're going to call somebody who's called a bail commissioner. And those people are appointed by the chief judge of the district court. And those people are authorized to act as justices of the peace or judges, essentially, of the district court for that purpose of setting bail while you're at the police station. And the Rhode Island rules of bail generally presume that you are entitled to be released on your own recognizance, which just basically means you promise to keep the peace and be of good behavior. You don't actually have to pay any money for bail, but you have to promise to appear at a certain time and day at court and come back. Now, there are other type of bail, could be surety bail. And that just means that they're going to set some amount of money. It's usually in the thousands. So let's just use $5,000 surety bail that they're going to set. You can post that in one of two ways. You can post that in cash, which you have to pay 10% of that directly to the bail commissioner, plus the bail commissioner's fee. And that varies depending on what time of night that is. Or you go get a bail bondsman if you have a relationship with one, and you pay 5% of that bail to the bail bondsman. That is non-refundable. The 10% would be refundable so long as you show up to all your court dates and you resolve your case.
Wow.
Yeah, it's an amazing system.
Right. So and one of the areas of controversy is the quote unquote elimination of cash bail. There's a lot of folks who are advocating for reform in the criminal justice system. What do they mean by eliminating cash bail? In other words, does that mean you're always going to be released on your own personal recognizance, depending on the severity of the crime?
Well, it could mean that Rhode Island basically has done away with straight cash bail, except for the situations where you owe restitution, and that's why you were in court. So they set cash bail on the exact amount of the restitution, and then you'll be released if you pay that. But some states you can set straight cash bail. So a judge, I think in Connecticut they do that. So the judge can set $500 cash bail. There's your bail. Rhode Island doesn't do that. So Rhode Island, you can still set surety bail. So you only have to come up with 10% of it, or 5% if you use the bail bondsman. But otherwise, you would be released on your own recognizance unless you've alleged to commit an offense that is considered a capital offense, where you could be held without bail for up until the time of trial.
A very common situation, sadly, for many Rhode Islanders is DWI/OUI, driving under the influence. And I think that there's a point probably where we should dedicate an entire conversation to this one night, or you should have subject matter experts on. But generally speaking, you're pulled over. You've been swerving. Now, as someone who recently got pulled over for being tired, and they took one look at me, and Peter Griffin, they're not taking Peter Griffin down to jail, right? They looked at me and one quick sniff and one quick look at me, and the let's just say the sheer volume of coffee cups littering my automobile, point out very quickly that I was in need of nothing more than a really good night's sleep, which, by the way, I still haven't gotten. So what's a procedure there? I mean, again, there's so many urban legends surrounding OUIs, and I'm not even saying that's one of your expertise, but generally speaking, what should someone do, and what are the ramifications?
So, Pat, I do a lot of DUIs in Rhode Island.
Okay.
It's one of the most common offenses that an everyday person who's not a common criminal, who's not a career criminal, can find themselves in. You go to dinner, you have a couple too many drinks, you swerve to get around a pothole, and you get pulled over. So, what I tell my clients and the advice I give my clients is be cooperative with the police to a point. And that point is, you give them your identification, you give them your registration, your insurance card, and you do as little talking as possible. Because these police reports for DUIs read like instructions. It's like a checklist. I approached the vehicle, and as I approached the vehicle, I noticed an odor of an alcoholic beverage emanating from the breath of the operator. The operator had slurred speech. The operator was fumbling around for his paperwork. And when I asked him for his paperwork, he had a hard time providing it to me. And, it was clear that he had glossy eyes and was under the influence of some sort of substance. So I tell them, do as little talking as possible, comply with the orders of the police. If they tell you to get out of the car, you have to get out of the car. What you don't have to do, and what a lot of people don't know, is that you do not have to do those roadside standard field sobriety tests. So the ones where they make you stand on one leg, the one where they make you walk and turn, the one where they shine the little light in your eye and they make you follow it back and forth to see if you have what they call nystagmus, which is like the shaking of your eye when it moves to a certain degree. You don't have to agree to those, and it's going to make their case a lot harder to prove that you are under the influence of anything, particularly alcohol, if they can't perform those standardized field sobriety tests. And then the issue always comes up of, do I take the breathalyzer or do I not take the breathalyzer? And that's a real personal decision, because if you've been drinking and you take the breathalyzer, it's pretty hard to say that machine is wrong unless it hasn't been calibrated correctly recently. So, it all depends at that point of whether or not you want to come down, whether or not you have a record, whether or not you've ever been pulled over for DUI before, and whether or not you want to have a criminal record going forward, or you just want to have a civil violation on your record, but you're still going to lose your license, because it's pretty hard to beat a breathalyzer refusal.
So the again, urban legend number 25 for tonight that we're slaying. I'm thinking that at this point in time, the police are relatively good at the whole calibration thing, and once you give it up for the breathalyzer, you're pretty much done if you've been drinking.
If you've been drinking and you take a breathalyzer, 9 times out of 10, that breathalyzer is going to come over the legal limit. Wow.
So the clear answer to it, first of all, is don't drink and drive. Don't be a knucklehead.
Yes.
I mean, it's there really, in the days of Uber and Lyft, there really is, and most businesses being cooperative about someone leaving a vehicle in a parking lot overnight, there really is no excuse to drink and drive at this point. There really isn't. Should you find yourself in that situation, though, comply with the police. But again, there's that decision moment. So if you don't take the breathalyzer, what typically happens at that moment, as long as you're not being violent, you don't have any other outstanding arrests. You don't. What's the next step?
So they're going to arrest you. If they think you're under the influence of alcohol, they're going to find a reason to arrest you. Whether it's the smell of your breath, whether it's because you didn't respond quick enough to their requests, or you refuse to take the standardized field sobriety test. They're going to arrest you. They're going to bring you back down to the station. They're going to ask you to submit to a breathalyzer. They have to give you a phone call. There has to be certain rights read to you at different points of the night. But at some point, they're going to ask you to take that breathalyzer. And if you refuse to do it, Rhode Island law says the first time you refuse to take that breathalyzer, they are going to issue you a civil violation to go to the Rhode Island Traffic Tribunal and face a breathalyzer refusal charge. That is a civil violation, not criminal. There are mandatory penalties that go along with that because Rhode Island has, like every state, has implied consent laws that when you have a driver's license issued by the state of Rhode Island, you have impliedly consented to taking a breathalyzer if you are asked to do so. And if you refuse to do so, they are going to suspend your license. And the mandatory minimum penalties, if you are found to have refused a breathalyzer and the police followed the protocol they're supposed to ask you to do so and you didn't, the mandatory minimum penalties of that are fines in the range of somewhere between $900 to $1,000 just in court fines. That doesn't mention even the DMV fines. You're going to lose your license for a minimum of 6 months. You are going to do at least 10 hours of community service, up to 60 hours of community service. You're going to pay a minimum of, I talked about the fines already, but there are fees and assessments that get added onto that, on top of it. And you're going to have to pay $300 or so to sign up for the alcohol education class that's offered at CCRI conveniently. And you can pay the DMV for that and complete that before you can get your license back.
So you are officially in a world of hurt.
It is a very expensive endeavor, and you haven't even talked about your legal fees yet.
Right. So,
and don't forget, you're gonna get charged with the DUI as well. They double charge. I mean, pretty much they're gonna double charge you every single time. And if you've never been in trouble before, up until I guess just a few days ago, standard practice in Rhode Island was if you didn't get into an accident, you didn't injure anybody, you didn't fight with the police, you weren't a jerk, you'll get the opportunity usually to plead to the refusal so you can save yourself a criminal conviction. My understanding is now the Attorney General has decided they're no longer going to follow that practice. And they are going to push both matters and make you go through both the criminal and the civil matter.
Wow, I haven't had a coughing fit on the air in months.
I hope you're all right over there.
Oh, no, just the thought of all this consternation. My understanding right now is that roadblocks effectively are illegal in Rhode Island. Is that correct?
Yes, the Rhode Island Supreme Court long ago ruled that roadblocks are unconstitutional under the Rhode Island state constitution.
So what is, in terms of the right to pull you over, what do they need for that?
So they just need reasonable suspicion that you have committed some sort of either traffic offense or criminal offense, and they can pull you over.
Which means they can pretty much easily pull you over.
Essentially, that's how it works. Now, it's a little tougher for, in the criminal context. It gets scrutinized a little bit more than it does when they're looking at it if in the breathalyzer refusal context, because the breathalyzer refusal is a civil offense, lower standard of proof. So, I basically had a judge of the traffic tribunal tell me they can pull you over for any reason they want, and as long as they follow the steps after that and you refuse to breathalyzer, they're going to sustain the violation.
Wow. It's if you've had a previous violation for driving under the influence, how quickly do the penalties ratchet up? And at what point in time do you, stop, do not collect $200 and go directly to jail? How quickly does it ratchet up from there?
Your second offense. If you have a second offense DUI, there is a mandatory minimum penalty of at least 10 days in prison. And the maximum penalty is 1 year in prison. But you have to do at least 10 days in prison. A lot of times, especially if you have nothing else on your record other than the DUI, the first DUI, they'll agree to allow you to serve that time in a home confinement situation, which basically means they strap that monitor to your ankle and monitor where you go on a daily basis, and they double the time, so it's usually around 20 or 30 days of home confinement as opposed to 10 days in the slammer. But that's the second offense, and on your third offense, it becomes a felony offense, and you're facing a mandatory minimum of 1 year in prison.
Now, the word is out there, and I'd love to know if this is true or not, but particularly on your first offense, if you need motor vehicle transportation to get to work, in other words, the Riptor doesn't go there, how likely are they to allow you that sort of limited license?
So Rhode Island does have the ability to get a hardship license and the ability to use the ignition interlock system as an alternative to just a straight suspension. Yeah, and that really, if you're a first-time offender, there was no accident, you were not. There are certain aggravating circumstances under the law that would give the judge the ability to deny you have that. You can petition the court to give you a hardship license as long as you would install the ignition interlock device in your vehicle, and you have certain times and days and a specific need to have to leave your home. So work would be, if I would lose my job if I can't go to work. So you have to say, dear judge of the traffic court or the district court or whatever court you're in front of, I work from these hours to this hour to this hour. I am driving during these hours. I would need to have a hardship ability to drive my license, a hardship license from this hour to this hour, or from this hour to this hour, and it cannot be more than 12 hours in a single day. And no judge is going to give you that full 12 hours because they're going to say you don't need to be driving for 12 hours. They're going to give you maybe 2 hours in the morning, 2 hours in the afternoon, or at night whenever you're driving. And they have if you haven't had any of those aggravating circumstances that are under the law, they are required to give it to you. Now, if you have an aggravating circumstance like an accident, or there was an injury, or this is not your first offense, then that's at their discretion to give that to you.
Wow. I will tell you from personal experience, having had to ferry one of those vehicles once, drive it from Seekonk, from a company that in Seekonk installs the interlock systems on up to the greater Foxborough area, up towards Norwood. Those are a pain to drive. They're painful. There's this intermittent necessity to blow into the system to keep it going. It's random, and it happens more often than you think. And it's far from a perfect system. And ultimately, it's pretty eager to screw it up and trigger a false negative or a false positive, I should say.
Yeah, and it happens while you're driving. And I've had clients tell me that, you'll be driving on the highway and all of a sudden the thing starts beeping at you because it wants you to pull over and blow into the machine. And to me, that part of it is troublesome because now you're creating a safety hazard that you're ostensibly trying to avoid, which is, not being able to safely operate a motor vehicle. And that I can't think of anything that may be more dangerous than something beeping at you and distracting you while you're driving 65, 70 miles an hour on the highway.
Oh, I've only had to do it twice, and it can paralyze. I mean, it's a terrible setup. Ultimately, as we have these conversations, and by the way, starting next week, the show will transition into your able hands. The point is, on all of this, don't do it.
That's the easiest answer is don't get into the system.
Right. Because ultimately, and I guess I want to close out with this subjective question. I want to give you an ample opportunity to engage in what we call here at the Coalition Radio Network with a variety of shows, shameless self-promotion. Once you get into the system, and this is sort of going to be a theme, I think, to a certain degree, and what we mean by in the system is when they run the check on you and all of a sudden your name comes up, you're known, as it were, to law enforcement. How quickly does the attitude change in terms of law enforcement's willingness to cooperate with you in order to minimize the impact of what may be a once-in-a-lifetime event on your life?
I can tell you it is a world of difference. If you get pulled over and they go back to their car and your name comes up that you've been all over the United States because committing crimes or traffic violations, whatever it is, they are, I mean, their attitude towards you is going to be different than the person who's never had any contact with the criminal justice system. And especially, that doesn't even include the people who may already be on probation, some sort of suspended sentence, parole. I mean, if you're on probation, and I'm just talking, I think the worst example, and I'm sure I'll catch some flack for this, but the worst example will probably be getting into the probation system in the district court, which is usually the court that handles misdemeanors. The district court, normally you go into court and, your case resolves. If you want, you can appeal to the superior court and the whole thing starts all over again, like the district court never happened. But if you go and you don't appeal and you're on the district court probation system, now the district court's got its claws in you, and that's where they have all their power, because you no longer have that immediate appeal right. Now you're in the system, and almost every person right now that goes before the district court and is presented as a probation violator or a suspended sentence violator, and because you've committed whatever it is, even the most minor offense, you are being held without bail for at least 2 weeks. 90%, I'd say at least 90% of the time, before they decide whether or not they're going to continue to keep you incarcerated simply because they believe you failed to keep the peace and be of good behavior.
Wow. There it is, folks. Starting next week, it will be the Calenda attorney at law. I'll be on the sidelines per se, but when you look at just within a half hour, the volume of pinpoint accurate information, these are the kind of conversations that I think are very valuable to people, because, again, we're all experts until all of a sudden it's 2 a.m. and you're sitting at a police station, or you've had your car impounded. By the way, I'm assuming with the OUI laws, your car is going to get hooked pretty much every time, isn't it?
Oh, well, at least they're going to hold it there until somebody who's at least safe to drive is going to come and take it. Right.
Yikes. And that's another, by the time you get done with storage fees and things like that, yikes. It's ugly out there, folks. It's a challenging system, but my hope is that in the coming weeks and months, we'll be able to have some really great conversations about the reality of this system. Chess, why don't you tell folks, we call it shameless self-promotion here, but we whether it be hosts and guests, we want to give people an opportunity to learn how they can reach out to you.
Well, as far as my legal services are concerned, I work at the law firm of Inman and Torgy. I'm in Coventry. It's 1500 Nooseneck Hill Road in Coventry. I can be reached at 401-823-9200. And like you've told everybody, I do mostly criminal defense law, but I also handle areas of family law, juvenile delinquency, certain civil matters. It really is a wide variety of things, but we do offer free consultations. I'm also available to be emailed at Calenda, CCALENDA @itwlaw.com. And that's what I do for my daily business. I'm a criminal defense lawyer for the most part.
Excellent. Well, the plan here is to have you on the air for about a half hour to 40 minutes every Wednesday night at 8:15 p.m. Eastern time. These shows will live on in perpetuity. You can find it on our Facebook and YouTube pages. We'll be setting up a separate category in the coming days on coalitionradionetwork.com. So, if you find yourself in situations like this, or you just simply want to educate yourself going forward on any one of a number of issues surrounding the law, then you'll be able to do so. And Chess, I want to thank you for joining us here on the network. I look forward to this. Areas that we're going to cover. I think you and I are, at some point, you're going to cover gun law in terms of both criminal violations as well as the licensing of, the permitting of. These are all areas just rife with challenges, and I look forward to working with you on a going forward basis.
As do I. Thank you for having me on again, Pat.
All right, folks, you've been listening to Chas Calenda, attorney at law, the inaugural episode. We covered a lot of material in an astonishingly short period of time. Unlike myself, Chaz, as you'll find, direct, short of words, but his words matter, which I would imagine he's learned from, countless opportunities to spend time in the halls of justice, which, as we say on the Coalition Radio Network, are often found in the halls. We're going to sign off for tonight. The Coalition Radio Network will be back on tomorrow, 7:30 tomorrow evening, with the golf dudes from Rhode Island Golf. A great show if you're a hobbyist or a serious player. Everything you need to know about the Rhode Island golf scene, you can find on Thursday nights here at 7:30 p.m. Listen, there's shoots of spring showing up. It's warm. People are playing on the weekends. Join us. Even if you don't play it, it's an awful lot of fun. And then, of course, we'll have Coalition programming tomorrow night on a variety of what we call third rail issues. We are the Coalition Radio Network, loud and proud, as always, outrage porn free, civilly disobedient media, broadcasting live on the worldwide Coalition Radio Network. Well, at coalitionradionetwork.com, facebook.com/the Coalition Radio, on the Mighty Mighty Twitter at Coalition_radio. All we ask is indie media, kind of the new guys in town. We've been on the air as a single show for over 7 years, but all we ask is if you follow us, like us, subscribe us, any one of the usual social media stuff. That's how we get our mission, our philosophy, our programming above the sort of white noise of, conventional TV, because I think we've got a lot to offer here in a long-form format. Have a wonderful evening, and we will